Good morning, Your Honors. Thank you for your time today. Attorney Sean Mullen, representing the insurance company in this workers' compensation matter, the National Union Fire Insurance Company. Your Honors, this accident occurred in a single motor vehicle accident, which occurred during the employee's commute home from his fixed place of employment. Now, for decades in this Commonwealth, accidents occurring on a commute to and from the fixed place of employment.
Well, let's say the man had a heart attack on driving home, and the evidence was that the heart problem was a direct result of the stress at work.
That's
no recovery?
I would argue no recovery. There are cases that indicate that there are certain injuries which occurred during the course of employment and are carried away from the job. The heart attack being one, and chemical exposure to noxious gases being another example of those types of cases. In this case, what we had was the trial court and the reviewing board trying to turn employment and the very work itself and the fatigue that comes from work itself being called an injury.
But let me ask you this question. Would you think, let's say, because I know this is this wasn't the case, or it's at least disputed, but let's say that this is a case, like in other states, where the employer really did require that he work all 27 hours straight.
Yes.
Would you say that would be different?
I would say that in this Commonwealth it should not be different, but in those other states, Your Honor is correct. There are other states which have found that when a person is compelled to remain at work for overtime without breaks, they have found that cases exactly on point, falling asleep at the wheel, are compensable. In this case, and the dissenting judge found in the reviewing board, in an extremely strongly worded dissent in this case, she found that there was ample evidence to the contrary, such as there is a carpenter's shack which was on the Central Artery Tunnel project.
Excuse me, before you go into all that evidence, wouldn't we have to find to rule your way, or wouldn't we have to conclude to rule your way, that the majority opinion of the reviewing board, that their decision was arbitrary or capricious?
Correct.
Or contrary to the law?
Yes, and that is in fact what the dissenting justice indicated in her dissent, and she explains why the majority was wrong. And to be clear, there was a majority, a concurrence, and a dissent. Now, I've been doing workers' comp for 15 years. It's the first time I've ever seen that, and I tried to find some other cases.
Right, but I understand the distinction between the dissent and the, quote, majority, but I'm not sure that the dissenter's reasons rise to the level of saying that the reviewing board was arbitrary or capricious.
It was contrary to law, Your Honor. The law in the Commonwealth has been, for decades, that these types of accidents in a commute are not compensable. And I should point out that with regard to Justice Botford's question regarding the cases where the employees were compelled to stay at work, in one of those cases, the dissenting justice, I believe it was in Virginia, and it's in my brief, indicated, he said, only this employee knew how sleepy he was when he left work. Only he could control whether he pulled over to the side of the road and took a nap or should be driving his vehicle. And that justice found that to hold that falling asleep at the wheel and getting in a car accident is the responsibility of the employer would be imprudent and improper.
But it was a dissenting opinion, and it's...
Correct, but again, I must point out that those cases are distinguishable from this one. Mr. Haslam was not required to work overtime. In fact, his union contract with the employer and with the Central Artery Tunnel project indicated that no employee can be compelled to remain at work beyond his regular shift. In addition, testimony came from his supervisor that 4 coworkers left at the end of their shift when they were asked to remain. Mr. Arruda, who was the supervisor, also testified that he had, quote, a slew of people that he could have called to come in to replace Mr. Haslam. Mr. Haslam chose to stay on the job when, in fact, it couldn't be further from the truth that he was compelled to stay. His union contract indicated that he did not have to stay. He had knowledge of that. He confirmed it through his testimony, and the judge so found in the lower ruling. So where the reviewing board made the mistake was to find that there was any exception to what we call the going and coming rule. That is, an employee getting injured after he has left work and is simply traveling home. I should also point out to Your Honors that in the cases where it has been found that there can be an exception, the cases indicate that the person was ordered to come to work and then had a motor vehicle accident, such as a nurse who got in a car accident on her way to work when she was called and they said, you must come to work. So any of the
Well, that's really, I mean, I understand that, but it is a going and coming requirement. So to go back to your other examples where, in answer to Justice Cordy, something could happen at work, correct?
This is true.
You're just talking about the fatigue cases, right?
Correct.
So are you saying to me that all of the fatigue cases have two requirements? One is that they're for mandatory, compelled, very long hours, and they were ordered to come to work?
Correct.
They were at work. I mean, the accident happened on their way out, right?
In the out-of-state cases, which in my brief I argue should not be followed in the Commonwealth, but I distinguish those out-of-state cases by pointing out, and so does the dissenting judge from the reviewing board, that in each of those cases, the person was compelled to stay at work.
Yeah.
For instance, in the case of Vander, this was a longshore worker. He was forced to stay at work for 26 hours. Forced. That's in the record. That is not so in this case.
I think the Chief Justice's question really was when you were saying about coming to work. Are you talking about the special errand cases?
Those, right. In the Commonwealth, the cases where they have made a distinction, all of those persons were forced to come to work.
That's the special errand issue. Right?
That's not the fatigue issue.
Correct.
Okay.
Correct. I'm distinguishing this case from both
Okay.
realms. And one of the arguments that the dissenting judge made in this case, in the Haslam case, is that if this case stands, what will occur is that the very work itself and the fatigue that comes from work could be deemed a personal injury. This is a very important case. If that is to stand, insurance companies will have to increase premiums in workers' compensation cases because injuries which occur at home, my example that I gave in every level, is if I go home and I'm chopping carrots and I cut my finger off, I can say I was exhausted because I had an extremely long day at work.
Well, I don't think you have to get there, Mr. Mullen, to say that at least if you're driving home. I mean, put it this way, all kinds of things can happen, but I think that would be far reach. But if you are driving from your place of employment to either your home or someplace else, and you have been compelled to work nonstop for, pick any number, 36, 48 hours, it seems to me that that's a different case than simply saying any accident that occurs thereafter.
Your Honor is correct, but I think the key phrase you used was if you are compelled.
No, I understand that.
And the evidence was much to the contrary in this case.
So what was he doing staying all this time? Just wanted to make some overtime money?
Well, there was a concrete pour, Your Honor, and to be fair to the employee, he was, in his words, trying to suck it up and do the right thing. That was what he said when he testified, that he wanted to stay and monitor the pour, the P-O-U-R. In addition, what's important to point out here is that this wasn't heavy labor for 27 hours. Most of it was observation time. I
don't think that makes any difference. I mean, it might make a difference, but sometimes just observation can be more sleep-inducing.
I mean, you don't need to argue with the facts about whether or not he was fatigued, right?
That's correct. I mean, I would even concede that he was tired on his way home.
Didn't the employee also say that he feared he might lose his job if he didn't stay to oversee the pour?
He made one subjective comment on the record, which was contradicted by his supervisor, who said, there's no way we could fire him, by 4 coworkers leaving, and he acknowledged when I cross-examined him that he knew that in the end they weren't sanctioned in any way whatsoever.
Finding a fact on that point?
Yeah, well, in the decision in the transcript, it was the evidence that was submitted.
It's evidence, but did anyone make a finding whether he could be fired, couldn't be fired?
I have to say,
I don't think there is a finding.
I don't believe so, Your Honor, but it was clear that was not the case, and he knew that. There was a subjective comment, well, I thought that I might get in trouble, completely contradicted by the supervisor who testified the same day, and by the fact that the 4 others that left were not terminated, and he knew that.
But with respect to that, I mean, the fact is one person stayed, and that's what they needed. So the fact that 4 others left doesn't really tell you very much, does it?
Yet, Your Honor, but he was not compelled to stay, and he did testify that he knew that. He knew he did not have to stay. In addition, there was a place where he could literally go and sleep and take a snooze. It's called a carpenter shack. You'll find that when you read the transcript from the hearing that the carpenters joked they called it St. Mary's because it was such a nice sleeping shack that one of the guys said, "What are you guys building, a church?" They all knew that they could sit and take a snooze. The supervisor indicated that he could have replaced this gentleman with a slew of people. He was not compelled to stay, and that is the difference between this case and those from out of state.
How many hours of overtime did he get out of this?
I think he got 18 hours of overtime. And what's interesting is he testified that the day before he worked a great length of time. I believe it was 8 a.m. to midnight. And he even testified, I slept from 12 to 3:30. I don't require much sleep. So he was taking a lot of overtime before this occurred as well.
I take it, it was a little unclear to me, and maybe I just wasn't reading it that carefully. At the beginning of the reviewing board's decision, they seem to suggest that he was compelled, namely he stayed until, all those long hours, and it was required, they underlined required, and then later on, construction supervisor on the job corroborated that it is necessary and they must be there. And then when they get to the discussion, further on, it says that they talk about impelled by his employment. Is there an implicit finding that he was impelled, if not compelled?
No, and I believe that's where the majority got it wrong, and I believe that's where the dissenting judge points out exactly how they got it wrong. And I believe that if you read my brief and the dissenting judge's opinion, you'll find that, quote, there was adequate evidence to prove to the contrary. He absolutely was not compelled. This was testimony that I brought out at the hearing level because I knew it was an important issue. He was not forced to stay.
Doesn't anybody make a finding of fact one way or the other on this?
Well, I mean, there's the error, Your Honor.
Aren't they supposed to?
Yes, and that's where the dissenting judge points out we need a fine, bright line in the Commonwealth of Massachusetts. At some point, the employer is no longer responsible for an employee when they leave the premises.
To send this back and get a finding on this point?
I don't believe so, Your Honor. I believe that on the law, this case should be reversed. The judge...
Essentially what the hearing board said was, so many hours, you must have a carpenter when there's a concrete pour. The concrete pour was delayed, must have a carpenter, no other carpenter shift coming in, irresponsible for this employee to leave, not, compelled, but this is a good employee. He says, look, I want to stay because of the delay. It wasn't as if this was a routine thing. Am I correct? There's a delay in the pour?
Yes, it was raining.
Yeah, for whatever reason. So he's the only person around, and if he leaves, the whole thing comes to a grinding halt.
He was not the only person around. The supervisor was also there.
Any evidence of what he said to the supervisor? Or
What Haslam said to the supervisor?
Or the supervisor said to
He
him?
chose to stay. He literally said, I decided to suck it up and stay.
Okay.
Could the pour have continued if the supervisor had stayed but Haslam had gone home?
Yes.
Did the supervisor stay as well as Haslam?
He was there, yes.
So, in other words, there was one unnecessary person there as far as supervising the pour goes.
Well, if Haslam had left, the supervisor would have stepped into his stead to
Right.
monitor that.
That's what I'm saying.
I mean, there's a lot more going on than just this
I
one thing for the
understand.
carpenters, right?
But the pour would have continued because there would have been somebody to watch it,
But
Yes.
i.e. the supervisor who was there anyway.
But the supervisor was doing a lot more than just watching this pour, right?
Well, he wasn't watching the pour because Mr. Haslam chose to stay.
Well-
Chose to stay.
Could have watched it.
He could have if Mr. Haslam had left. Or, as he testified, I had a slew of people on the phone that I could have called in. And again, there was a delay between when the pour started and when Haslam decided, I'm going to stay and take this overtime. And that's when the call could have been made.
Was there was some kind of request by the supervisor or an inquiry by the supervisor of Haslam, do you want to stay, or I'm going to call the other people to come in, or how did that play out?
That didn't come out in the testimony, Your Honor. But again, I think if we focus too much on was there another guy there, he chose to stay. And in this Commonwealth, we have followed this rule. It has to be a bright line. An employer cannot be held liable for someone driving home from work in a fatigued state.
I'm just looking at page 209 of the appendix, which is the findings of the
Administrative judge.
Initial judge, right?
Yeah.
Seems to suggest that he said, though he, that is Mr. Haslam, allowed that overtime was not compulsory, the night crew had been laid off and there was no relief. He testified to having wanted to get out of the overtime, but to sucking it up and continuing because the job had to be done and because he felt there could be repercussions on the possible loss of his job. Now, if you're saying that that's finding is based on, it doesn't have any evidence to support it, that's one thing, but that is the finding.
Right, and in the initial appeal, when you appeal to the reviewing board, I appealed that as erroneous as well, pointing out to the reviewing board all of the contrary evidence which the dissenting judge found. There was ample contrary evidence to that finding. And the judge even goes so far, the dissenting judge, as to point out that a subjective fear of termination is not enough to indicate that he was compelled.
So you say that's arbitrary and capricious?
Exactly. The lower judge made error as well, and that's how we got to the reviewing board. Again, this case could not be more important in terms of the future business aspect in the Commonwealth of Massachusetts and what will happen to insurance premiums if this is allowed to stand. If an insurance company has to insure accidents that occur because someone is tired, and fatigue and being tired is subjective, as I pointed out in my brief and as the dissenting judge agreed. How tired is tired? Are we going to have judges literally saying, well, he was really tired, not so tired, not tired at all, and had an accident on the way home?
But wouldn't you concede that if, in fact, the employer, I mean, I'm going around the Marbury Bush again, but wouldn't you concede that if the employer compelled or impelled him to work 27 hours, that this is not an unlikely event, that there should be workers' compensation?
It's certainly not unlikely, but the testimony also came out that this employee and other employees, before they went home, would rest in the shack, would have coffee. There are other things he could do.
But you're suggesting that a finding in this case will mean that whenever somebody is tired going home from work, that'll have to be factored into the compensation rate because it'll potentially be covered. But that's not this case. If we were to conclude, the board was right in concluding this person was impelled to spend 27 hours, how does that affect every single driving home case from?
Well, the facts of this case are that he was not compelled or impelled to stay, number one. Number two, I can tell you as an officer of the court that attorneys are already citing this case and trying to make claims for people being tired and getting hurt at home.
Okay. All right.
Thank you, Mr. Mullen.
Thank you.
Good morning, Mr. Moletti.
Good morning, Your Honor.
Mr. Moretti, I understand that there's a distinction between somebody driving home and getting into an accident and then somebody cutting his or her finger off while cooking at home. But once you open the door, so to speak, the next step, the next employee will be back saying, but I cut my finger off because I was so tired from the job.
I don't think so, Judge. Number one, the Act has been around since 1911. This is the first time it's occurred. Secondly, the condition of employment was not fatigue or tiredness. The condition of employment here was that the employee was required to work 27 straight hours.
But he wasn't required.
Compulsion has never been a requirement under Massachusetts. It's enough if he was impelled by the employment activity itself or he was engaged in an undertaking for the benefit of the employer.
But we don't have a finding.
Certainly working 27 straight hours, Justice Cowan, is an undertaking for the benefit of the employer. Compulsion is not the standard.
We don't have a finding that he was impelled by the employer. The judge says he testified he testified that he felt he had to suck it up and he felt he was impelled. That's not a finding. He says he testified to that.
Respectfully, Judge, I think what you're equating is impelled with compulsion. They're two different things. And secondly, it is under the heading of subsidiary findings of fact. There were, as to also address Justice Graney's point, there was conflicting testimony. The employee testified to one thing, Arruda testified to the other. Arruda's statement is not contained in the findings of fact at all, but the employee's statement is contained in the findings of fact, and I would submit to this court that what the administrative judge did was he found that there was compulsion, or at least he was impelled to do so by the employment. The fact
Let's say the union negotiated a contract here saying that we want 24-hour shifts. We want our employees to work 24 hours, then off 24 hours, then work 24 hours, then off 24 hours. And the person gets tired going home. Is that the employer's problem?
Well, that's kind of far-fetched.
Impelled?
It's
It's
not
not far-fetched. We just had that case not too long ago, right here.
Police contract.
Firefighters.
Oh, police, right.
Firefighters.
Police isn't covered
They
by
want
that.
24 hours.
No, I understand, but you've
Right.
got, I understand it's a different thing, but I mean, increasingly people want to negotiate longer and longer periods of time. It works dual career families, it works all kinds of things.
Well, I think the difference there, judges, is that it would be something that was bargained, and that's
Oh, I
totally different than
understand.
what this is.
Let me just go back. It's 27 hours, so there's something magical about 27 hours?
No, that's just happened to be what he worked. It was 27
But you said it
straight
wasn't fatigue.
No, if I may just back up for a minute,
Yeah.
there's two ways to look at this case. We've been talking only about the going and coming rule, but there's also, based on the adopted expert medical testimony in this case, it can be looked at in two ways. One under the going and coming rule, the other under the more restrictive traditional causation analysis. Here, the administrative judge adopted the opinion of Dr. Auerbach. Dr. Auerbach opined that the motor vehicle accident quite clearly was related to extended sleep deprivation. Nowhere in his report does he mention fatigue. And he said the sleep deprivation occurred because of the extended work shift. The medical evidence here provided a clear causal link between the accident itself and the employment activity. The employment activity was 27 straight hours of work. That's what it was.
Well, let's say the employee, and Lord knows this surely happens on a big project, wants to earn as much as humanly possible.
Sure.
Because this is a short-term project, a lot of money to be made, and just signs up for every overtime shift. It works 24 straight hours. Just signs up, I want to do it, and has an accident on the way home.
Sure, that could happen.
And
But
the employer's responsible? I mean,
yes, the employer would be responsible because he was engaged in an activity on behalf of the employer, and that's what the law states.
But a voluntary
But that's what the
one.
law states in Massachusetts.
And
But
you're
as
saying
as Justice Botford mentioned, that's not what the employee did here. He wasn't working because he wanted the overtime. The testimony was, on page 209, he said that he stated that overtime was not compulsory. The night crew had been laid off and there was no relief. He testified that he wanted to get out of the overtime, not that he wanted to get out of it, but had to suck it up. And he continued because the job had to be done and because he felt that there could be repercussions up to the possible loss of his job if the job was not completed on time. He was just not merely a carpenter on the job. He was the carpenter foreman. The supervisor, Arruda, as Justice Botford mentioned, he was in charge of many other things. He was in charge of the cement. He was in charge of the electricity. He was in charge of the electricians, rather. He was in charge of other laborers, but with respect to the carpenters on this job.
Do you dispute that the supervisor could have called in other people to do this same work that Mr. Haslam did?
There is no finding by the administrative judge of that Judge Ireland. However, Mr. Arruda did testify to that. There is testimony, but there is no finding of fact as to that. It wasn't credited by the administrative judge. But all of this is really immaterial. It's really irrelevant to the issue of this case because it doesn't matter whether he was forced to do so or he voluntarily worked. I mean, he could voluntarily work as long as he's traded away a lot. He's traded away his tort rights. So this is more of a summary process. As long as he's engaged in an undertaking, and I know I'm repetitive, but this is the law.
What-
As long as he's engaged in an undertaking for the benefit of the employer, and certainly working 27 hours here.
Yeah, but that could happen after an 8-hour shift.
Yeah.
You could get tired after working 6 hours, and
Sure,
you
you
could
could
even
get-
have another job, and then come to this job, and you get exhausted, and you drive home, have an accident. Is the employer responsible in these circumstances?
Well, no. Well, what the employer can do there, Judge, is that he would have the benefit of a defense under 17A because it was a pre-existing condition. And the pre-existing condition is he was out all night, he was
No, but
doing
let's-
whatever he was doing, and therefore,
But you say so long as there's okay, let me forget about the other job. So a person gets tired working 8 hours at this particular job. He produces medical testimony to show that there's a nexus between the job and the fatigue and the accident that he has on the way home. We're going to have people falling asleep all the time.
I don't think so, Judge, because it's not fatigue, it was sleep deprivation. Working 8 hours, I don't think that there's too many medical professionals out there that are going to say that you can't work an 8-hour shift, and that by working an 8-hour shift, there was sleep deprivation, and therefore your motor vehicle accident was the result of sleep deprivation.
But you could be
Everyone has
somebody-
classified this as fatigue, but it's not fatigue.
Okay, but let's just take sleep deprivation. It
Okay.
means that all these, let's just take police officers who, I mean, this is what Justice Court is talking about, rack up the overtime because you get great pay, it's overtime, but you're working 23, 24 hours longer. And why should we encourage that?
Police officers are not governed by the
Well,
Workers'
anybody.
Compensation Act.
Anybody. These big dig workers, I mean,
Okay,
same thing.
sure.
Voluntarily, they sign up again and again because it's great pay, and this job is not going to last forever. But they are really impaired by sleep
And
deprivation.
the employer has a responsibility here. The employer has a responsibility not only to the worker driving home, but also to other workers on the job. And perhaps, maybe there's something wrong. Let's take the big dig. Maybe because of sleep deprivation, they didn't build that tunnel correctly. Maybe the tiles weren't installed correctly. I'm not suggesting that happened. But just as a, since we're all supposing here, as a supposition, let's say that happened. Well, the employer, I think, has an obligation.
Who has
an
the
obligation to
why does it only rest on the employer? In other words, I drive a motor vehicle, correct? And if I know that, for whatever reason, I'm flying from, Buffalo, and it's delayed, and I'm up, and it's, I'm tired, and so, he knows that he was tired when he got into that car, correct? Why doesn't he have an obligation not to get into a vehicle when he knows he's tired, when he's suffering from sleep deprivation, any more than he knows if he's otherwise impaired by substance abuse or emotional threat or diabetic, seizures? Why do you want to put all of the responsibility onto the employer?
Because, Chief Justice, what you're adding here, which is not present in workers' compensation, is you're adding the element of negligence, of contributory negligence,
No,
of assumption of the risk. You are, but that's not the standard. What the rule.
If it's a compulsion one, I can well understand. The employer says you must come.
Sure.
And for some people that might be 12 hours. I have friends, I'm sure you have friends, who say, look, at the end of 10 hours, I'm dead, I'm asleep, right? So the compulsion one I have no difficulty with. We also have friends, certainly going back to college, who just seem to be able to go for hours and hours and hours, really quite productively. So those people want to work additional hours. The compensation is good, the pay is good, they're getting overtime, and they function perfectly well. If somebody knows that they don't function well, how can the employer make that on a case-by-case, other than to say there's no overtime?
Well, the difficulty, the fact of the matter is that it is fact-specific, and it has to be on a case-by-case basis. If you look at this particular employee himself, the previous day he had worked 15 hours, and he only received 3 or 3.5 hours of sleep, but that was sufficient for him. Everybody's different. And what we have here that's different than just the going and coming rule is we have expert medical testimony. It was Dr. Auerbach who examined him that said that the employee could rejuvenate himself, this particular employee, with short periods of rest. So he did it the prior day. But then after he got that 3.5 hours of rest, he then worked for 27 straight hours.
Could the
And that was a
employer
little bit
have
too much.
denied him the overtime? Can the employer say, no, you've worked too much, you can't have any more overtime today?
Absolutely. It was the employer's obligation to replace Mr. Haslam in this job.
And he could deny him the overtime?
Yes, he could send him home, yes.
Could you explain how you think this fits within the special errand? I mean, it just seems so different to me.
Well, I think that it is part of the special errand. It's a subset of it, Your Honor, for an inconvenient or hazardous trip. And, I mean, the Vandervander case is the case that's probably it's most similar to, and in that case, as Mr. Mullen was.
But that's a fatigue case, isn't it?
No, that's a sleep deprivation case.
I mean,
yeah.
it's not. I thought that you're sort of saying.
Oh, okay. Let's take the chemist case.
Yeah,
I can't say the guy's
case.
name. It was Papa.
Papatantasio or something like that.
Yeah, that's
Yes.
it. All right. Here's a guy that was doing a research assignment. It wasn't completed during his normal shift. He went home. He had his dinner. After his dinner, he drove back to work to check the readings, and he got into a motor vehicle accident and was severely injured. That was compensable. That was a special errand. In this case, is it any different? Here's the guy that was raining. The weather was terrible. They couldn't continue with the pour. They had to wait until the weather cleared. Should the result be different merely because he's able to leave, go home, the rain clears, and he drives back in and either gets an accident coming in or an accident going home? That automatically would be a special errand because he left the job site. Why is it because he remained on the job site waiting for the rain to subside that it takes it out of the special errand exception? I don't think it does. I think the facts are very similar.
Explain to me why it's important that this isn't fatigue, but it's sleep deprivation. Why is that an important distinction?
Because this is what the medical evidence was. This is part of the causation.
So if the medical evidence was he was fatigued, you wouldn't be here? Or you just say that's the causation?
No, I wouldn't. Well, no, because the fatigue, it doesn't really matter because this is not the condition of employment. The condition of employment was working 27 straight hours. You can classify it as fatigue, or you can say the fatigue was the result of sleep deprivation. I'm only going by what the actual facts of the case are. And if you look at Dr. Auerbach's medical report, his report said that the accident happened because of sleep deprivation.
Yeah, but
it
you
doesn't
also
say
know
because of fatigue.
that the
I mean, I can be lifting things and my muscles can be fatigued.
So this case really is a case about whether or not the employee was impelled to work 27 hours that resulted in fatigue, that resulted in the automobile accident.
No.
Your argument is it doesn't take any kind of compulsion, or it doesn't have to be impelled, just the fact that
No,
he
it does
worked.
have to be impelled. He has to be impelled by the employment itself. He must be engaged in an undertaking for the
So if he
benefit.
strictly volunteered to work 3 straight shifts, volunteered,
covered.
it could have been anybody else that worked it, then there's no claim.
No, there is a claim. If he volunteered to work 3 straight shifts and he got into an accident, he was impelled by the employment itself. He was doing the job of that he was supposed to do.
Impelled doesn't mean anything.
No, it really doesn't. Not in workers' comp. As long as he was engaged in an undertaking for the, this is probably the 10th time I've said it, but that is the rule.
And in your view, it doesn't make any difference how many hours he worked. If so long as he was engaged in some beneficial activity for the employer and was fatigued as a result of that and injured.
Deprived of sleep.
No, I think you do have to look at the hours. I think the hours are a component of it, Judge. There are cases that say that you could work 1, 2, 3 hours of overtime, and that's not enough.
We had the firefighters in here saying national studies, 24 hours is not a problem.
Yeah.
Mr. Moetti, what do we do with the fact that the ALJ accepted the expert testimony of the Dr. Auerbach, or whatever his name was, or her name, but then also said, and oh, by the way, just as a matter of common sense, I would support the same thing. I would conclude the same thing. You know where he says that? He says...
well, yeah, I think that we can all say, I mean, I don't know. Maybe the court can stay up for 27 straight hours, but I can't. I think that it's just, everyone can just, in ordinary life, say, there's a 27-hour day. Most people need some sort of sleep, whether it be 8 hours or 3 hours. They need something.
There are now studies saying this entire nation is sleep deprived. So,
yeah. So that you need something. But I think the fact that the administrative judge concurred or felt the same thing as Dr. Auerbach is really not important.
Thank you, Mr. Moetti.